Welcome aboard, applicants. We're going to be talking about criminal law today. Our criminal law shopping list, as you may recall, is murder, structure, theft, crimes against the person, solicitation conspiracy, attempt, and defenses. So let's dig into each one of these and see what we can review. Under the topic of murder in our shopping list, we have homicide. Homicide is the killing of a human being by a human being. Make sure to keep a close eye to see if the 1 year rule, which means that the victim died within a year and a day of the crime that caused the particular homicide. Okay, and so to recap homicide here, homicide is the killing of a human being by a human being. Make sure to keep an eye out for a year and a day rule. Okay, now the actual cause. Actual cause is a factual cause. Actual cause is proven by the but-for test. But for the actions of the criminal defendant, the victim would not have died. Proximate cause. Proximate cause is established by foreseeability and looking at the intervening events. Foreseeability is whether or not it was reasonably foreseeable that the conduct taken by the defendant would cause death to the victim. Murder, malice aforethought. In murder, the murder definition is unjustified killing of a human being by a human being with malice aforethought. Malice aforethought is established by the mental states of intent to kill, felony murder rule, intent to cause serious bodily harm rule, or intent to cause serious bodily harm murder, and depraved heart murder. So just to recap that again, murder is the unjustified killing of a human being by a human being with malice aforethought. Malice aforethought is established by the mental states of intent to kill murder, the felony murder rule, intent to cause serious bodily harm murder, and depraved heart murder. Now, when you establish that murder has occurred and then the malice aforethought, the applicable malice aforethought has been talked about, we then now look at degrees. In degrees, we're looking at first degree. For first degree intent to kill, we're going to be looking at premeditation and deliberation. Premeditation is the pre-thought out plan to kill by the defendant to kill the victim. The deliberation is the cool mind capable of reflection upon that plan in carrying out the killing. Now, first degree felony murder can be accomplished by the commission of an inherently dangerous felony, which may include burglary, arson, robbery, rape, kidnapping, and other serious felonies. Second degree murder includes all other malice aforethought states not included in first degree. Now, or another way of putting that is second degree includes all mental states not within first degree. Now, after establishing the degree of murder, we're going to be looking at justifications. Self-defense is one of those. Defense of property is one of those. Defense of the defense of others is one of those. Crime prevention would also be one of those. Also, we're going to be looking at excuses. Excuses will include intoxication, voluntary and involuntary, insanity, and incapacity. Incapacity due to age or anything else that would affect the person's ability to be able to have the mental state necessary for the homicide or the murder. Basically, the mental state is what incapacity addresses. Voluntary manslaughter. Manslaughter is homicide without malice. Now, voluntary manslaughter may be proven in one of two ways, primarily in one of two ways. The heat of passion offense. In the heat of passion offense, we're taking a look at whether or not there was a reasonable provocation by the defendant to kill the victim, and whether or not the defendant was actually provoked. Then we're going to look at whether or not a reasonable person would have had an inadequate time to cool off, and whether or not the defendant cooled off. And if those all lean towards the direction of the fact of the person being provoked and having no time to cool off, then you may have a heat of passion defense argument. Now, let's say our self-defense argument doesn't prevail because it was unreasonable. We would now mitigate that self-defense through voluntary manslaughter to imperfect self-defense, which is an honestly but unreasonable belief that the person's life was about to be taken or the person's life was in danger. Now, if that doesn't provide a mitigation of the homicide to manslaughter, we're going to be looking at involuntary manslaughter. And involuntary manslaughter can be proven by two ways: criminally gross negligence and the misdemeanor manslaughter rule. In the criminal gross negligence, we're looking at whether or not the conduct taken by the defendant posed a substantial or significant risk to the life of the victim, and the criminal defendant disregarded they disregarded such awareness of such risk of life, or the risk to the life of the victim, and engage in that conduct anyway. So to recap that, criminally gross negligence is when the criminal defendant takes a particular course of conduct that significantly and substantially poses a risk to the life of the victim. Misdemeanor manslaughter rule is when there's a homicide that occurs as a result of the commission of a misdemeanor. This would be things like traffic violations, parking violations, and the sort. So that is our murder template in a nutshell. Now, switching gears to structure crimes. Common law burglary and modern law burglary. Let's talk about those. Common law burglary is the breaking and entering the dwelling house of another at night with the intent to commit a felony therein. Again, recapping that, common law burglary is the breaking and entering the dwelling house of another at night with the intent to commit a felony therein. Modern law burglary is an entry into the protected structure of another with the intent to commit a crime therein. Common law arson is the malicious burning the dwelling house of another. Again, recapping that, common law arson is the malicious burning of the dwelling house of another. Modern law arson is the malicious burning of the protected structure of another. Excellent. So now we can go to, after we've addressed structure crimes here, we can now go down to theft crimes. Theft crimes can be broken into larceny, robbery, embezzlement, false pretenses, extortion, blackmail, receipt of stolen property, and don't forget about our defenses. Larceny. Larceny is the trespass, retaking, carrying away the personal property of another with the intent to permanently deprive the owner thereof. Again, to recap that, larceny is the trespass or retaking, carrying away personal property of another with the intent to permanently deprive the owner thereof. Now, robbery is technically larceny plus force or threat of force, but we will choose not to say it like that. So we will say robbery is the taking of another's property by force or threat of force with the intent to permanently deprive the owner thereof. Again, recapping robbery. Robbery is the taking of another's property, the trespassory taking of another's property by force or threat of force with the intent to permanently deprive the owner thereof. Embezzlement is the taking of another's property with lawful prior possession coupled with the conversion of that property for the criminal defendant's own personal use. Okay? So embezzlement is the the taking of another's property with lawful prior possession coupled with the conversion of that property for the criminal defendant's own personal use. Then false pretenses is the false representation which causes the victim to pass title. False pretenses is technically a false representation that causes the victim to pass title to their personal property. Again, to recap that, a false representation that causes the victim to pass title to their personal property. Extortion blackmail is the trespassory taking of another's property by the threat of future force or the threat of future force with the intent to permanently deprive the owner thereof. Again, extortion blackmail is the trespassory taking of another's personal property by future force or threat of future force with the intent to permanently deprive the owner thereof. Receipt of stolen property is the receiving of property with the knowledge that the property in question is stolen. The receipt of stolen property, again, to recap that, is the receiving of personal property with the knowledge that said property is stolen. The defenses we're going to be looking at here are retaking own chattel and the defense of claim of right. Crime against the person now, further down in our shopping list, is assault, or includes the elements of, or the issues of assault, battery, false imprisonment, kidnapping, rape, mayhem. Now, assault is the intentional act by the defendant that causes the plaintiff, or causes the victim here, to suffer a reasonable apprehension of receiving a harmful or offensive contact. However, there are three variations of assault. There's aggravated assault, where the assault occurs during the situation, or during or the assault occurs as a result of an aggravated circumstance. An aggravated circumstance may include deadly weapon, which would also include the aspects concerning the situation is such that the threat to life is significant, and therefore all of those surrounding circumstances would evident an aggravated circumstance. So, the aggravated assault is an assault that occurs during a situation, set of circumstances, surrounding circumstances that have been aggravated due to the presence of a significant threat or danger to human life. Then, under attempted battery by definition is an unsuccessful battery. Then the unsuccessful battery or attempted battery assault is a way by which assault can be a specific intent crime. And we'll talk about that later on in our shopping list here under the defense of like intoxication and voluntary intoxication specifically. Now, apprehension is the classic assault that we just talked about, the act by the defendant that causes the victim to fear or reasonably apprehend a harmful or offensive contact with their person. Now, that would be in a nutshell what assault is in our crime against the person issue. Now, battery is a action by the defendant that causes the plaintiff to suffer a reasonable apprehension. It's an action by the defendant that causes the plaintiff to suffer a harmful or offensive contact with their person. Or said a little bit differently, it would be an unjustified harmful or offensive contact with the victim's person. False imprisonment would be the action by the defendant that causes the plaintiff's person to be confined to a bounded area with no reasonable means of escape. So it's actions taken by the defendant that causes the victim's person to be confined to a bounded area with no reasonable means of escape. And we're looking to the topic at times in false imprisonment is whether or not the victim was aware of their confinement. Even if they are not aware of their confinement, the criminal defendant would still be liable, because if the victim is harmed by their confinement, that criminal defendant would still be liable. Okay, now down to kidnapping. Kidnapping is a action taken by the defendant that confines the victim's person to a bounded area with no reasonable means of escape, plus the element of movement. So kidnapping is, in essence, the criminal defendant taking a course of conduct that causes the plaintiff's person to be confined to a bounded area with no reasonable means of escape, plus the element of movement. Now, rape is a it is the non-consensual intercourse with someone not the criminal defendant's wife. Okay, so it's non-consensual relations with a person, the victim, not the defendant's wife. Okay, now down to mayhem. Mayhem is a permanent disfigurement of the victim's person. Action by the defendant that permanently disfigures the victim's person. Now, after having taken care of crimes against the person element in our criminal law shopping list, let's go now down to solicitation conspiracy. Now, solicitation is the asking another, encouraging another to commit a crime. No more or less than that. Plus, you might even add the element of intent there. So we'll include that in our rule. Solicitation is the asking or encouraging another to commit a crime with the intent that the crime be committed. Now, down to merger. Remember, solicitation merges with conspiracy, but conspiracy never merges with its target crime. That's in essence what merger is. Again, in essence, merger is the definition that it provides that solicitation merges with conspiracy, but that conspiracy never merges with the target crime. Conspiracy is the agreement between two or more people to commit a criminal act or commit a lawful act in a criminal manner. Again, conspiracy is the agreement between two or more people to commit an unlawful act or to commit a lawful act with unlawful means. Pinkerton's rule is the legal theory that states that actions taken by co-conspirators are liable. All co-conspirators, I should say, are liable for the actions of other co-conspirators if those actions are in reasonable furtherance of the conspiratorial objective. Stated again, all co-conspirators are liable for actions taken by other co-conspirators if those actions are in reasonable furtherance of the conspiratorial objective. Now, accomplice liability is the aiding and abetting another in the commission of the crime with the intent that the crime be committed. Again, accomplice liability, by definition, is the aiding and abetting another in the commission of the crime with the intent that the crime be committed. 4 types of accomplice liability to look out for: principal in the first degree, principal in the second degree, accomplice before the fact, and accessory before the fact, and accessory after the fact. So, principal in the first degree, principal in the second degree, accessory before the fact, accessory after the fact. Okay. Receipt of stolen property, like above, we said that it was receiving property with the knowledge that said property is in fact stolen. Felony murder rule is a foreseeable homicide that occurs during the commission of an independent, inherently dangerous felony. Again, felony murder rule is a foreseeable homicide that occurs during the commission of an independent and inherently dangerous felony. Watching out at this point for the red line rule. The red line rule is this: there is no liability for the death of a co-felon by the surviving co-felon if the death of the co-felon was committed by a bystander, the victim, or a police officer. Again, restating that a co-felon is not liable for the death of a co-felon if the death of the co-felon was committed by a non-co-felon, a bystander, the victim, or a police officer. Misprison is in essence this: when the criminal defendant is arrested, they hold information that would lead to the conviction or that would lead to apprehending that would lead to the apprehension of a co-felon, and they don't disclose that information. That would be misprison. So misprison is when a co-felon who is arrested withholds information that would lead to either the arrest, the conviction, or anything leading concerning the particular felony in question, or the other co-felons, or the other co-felon or co-felons. So let me restate that again. I know I'm doing this 3 times, but misprison is when a co-felon holds information that would be relevant or important to the felony in question or to the conviction or apprehension of a co-felon. Something along that line would suffice for misprison. Now, attempt is an incompleted crime in its basic definition. But now let's go into its elements. The uncompleted crime or incompleted crime has the elements of specific intent, and that's why attempted crimes automatically are bumped up to specific intent crimes. Specific intent would be things along the lines of, like, in larceny, it would be the intent to permanently deprive the owner thereof. In burglary, it would be the intent to commit a felony therein. But these specific intents also supply what would otherwise be general intent crimes, like battery, with specific intent elements. Okay, so we would fill in the specific intent with the relevant intent that the party is committing the crime to accomplish. So it's basically intent plus in essence, and it's that plus intent that we're looking at in specific intent. Now, impossibility. Now, I also want to make a mention here. I'm going to type this in here. The only for attempted murder, the only mental state, the only malice aforethought mental state that would suffice for attempted murder is, you guessed it, intent to kill murder, because it's the only expressed malice aforethought mental state that works, because attempted murder requires an expressed malice aforethought state to make the attempted murder charge. So keep that in mind. Now, impossibility. Impossibility has two elements in it. It comes in technically 2 flavors: the impossibility, factual impossibility, and legal impossibility. Factual impossibility is the one where the criminal defendant thinks that a set of facts is going to go like they think it's going to go one way, when in actuality it goes the exact opposite. So that would never supply a defense for the criminal defendant. So it's never, factual impossibility is never a defense. The definition of factual impossibility are the facts went contrary to how the criminal defendant thought they were going to be carried out. Now, then legal impossibility is saying that what the criminal defendant thought they were committing, what what they thought they were committing was a crime was in actuality not a crime at all. So it's called legal impossibility, that what the criminal defendant was engaging in and what they thought was a criminal course of conduct was in actuality not a crime at all. Now, parentability is simply that the criminal defendant carries or has the apparent ability when they go in to commit the particular crime in question. Now, the next element, preparation versus perpetration, this is establishing whether or not we have a sufficient performance taken by the criminal defendant. Now, this would be established by substantial step. The Model Penal Code provides the substantial step test. Has the defendant gone from mere preparation to actually perpetrating the crime, and therefore taken a substantial step in the commission of the crime? Also, another test that may help is called the proximity test, meaning that the next proximate act necessary to complete the crime would have been the actual 100% completion of the crime. So the proximity test is saying that the next proximate act would have completed the crime in question. And these establish whether or not we're in mere preparation versus actual perpetration of the crime. Now, down to defenses. These defenses would be non-homicide type defenses. We're looking at self-defense. In self-defense, measured by an objectively reasonable person, whether or not they believed that their life was in immediate danger and that reasonable force was necessary to meet that danger. So you assess what force you're facing and then determine what amount of force you can apply to the force that you're facing. So it's self-defense would be a reasonable person in the criminal defendant's position would have understood, or self-defense would say that a reasonable person in that particular situation would understand that their life was in immediate danger, and that the force that was taken was the reasonable force to meet that immediate danger force. Okay. Now, defense of others. The defense of others is dependent on whether or not the other in question that the person is coming to the rescue of can in fact defend themselves, and with what level of defense can they defend themselves. In essence, we're looking at the stepping into the shoes aspect. Can the others we're talking about here defend themselves with deadly force in terms of a self-defense? Can they defend themselves with non-deadly reasonable force? And so that's why in defense of others we have to assess that. Now, defense of property. In defense of property, we're looking at reasonable non-deadly force. The exception to that might be where in the Castle Doctrine theory, we're looking at whether or not the defense of property, also intricately tied in, would also involve a threat to the life of another, okay, or that particular party in question. So defense of property, mainly reasonable non-deadly force, but in special exceptions you may have deadly force, reasonable deadly force, dealing with not only the defense of property but also the immediate threat to the life either of the victim or of another. Now, insanity. In insanity, we're looking at due to a disease or defect of the mind, the party in question who's exercising this particular defense should be able to say that they could not form the necessary malice, the necessary mental state, okay? The mens rea necessary for the commission of the crime. Now, in the McNaughton, we're looking at whether or not the defendant, due to a disease or defect of the mind, did not understand that their conduct was morally wrong. The right or wrong test is what some people call it. And also another definition of McNaughton is that due to a disease or defect of the mind, the party in question did not understand the nature or consequences of their conduct. So, or the quality and nature of their conduct. Now, looking at irresistible impulse, we're establishing the same thing, but through a different means, and we're saying that due to a disease or defect of the mind, the party in question had an irresistible impulse to commit that particular criminal activity. In other words, that even if a police officer were looking over their shoulder, they would still commit that particular crime because they have an irresistible impulse to commit that crime. Now, looking at the Model Penal Code substantial factor, with the third of our insanity defenses, we're looking at whether or not, due to a disease or defect of the mind, the party in question, the defendant, cannot conform their conduct to socially acceptable mores. In other words, it's technically McNaughton plus, that due to a disease or defect of the mind, the defendant cannot conform themselves to socially acceptable behavior. And that, now going to our last insanity defense, the Durham defense, we're looking at, this is called the product defense, that the criminal defendant course of conduct was a product of their disease or defect of the mind. And so again, under Durham, the definition would be that the course of conduct taken by the defendant was a product of their disease or defect of the mind. Now, intoxication is looking into whether or not the defendant can form again the necessary mental malice aforethought state. Or I should say, it's not in malice aforethought for homicide, but the necessary mental state for the crime, the mens rea. Now, voluntary intoxication is where the criminal defendant voluntarily takes on the intoxication. Now, this is a defense to specific intent crimes, but is not a defense to general intent crimes. On the other hand, involuntary intoxication, where a party does not voluntarily take on the intoxicating substance, that would also be a defense to specific intent crimes, and it would be a defense to general intent crimes. Necessity as a defense would say that the course of conduct taken by the defendant was necessary in order to avert a greater result. So this is more of the choice of evils argument, that the course of conduct taken by the defendant was necessary to avert a greater consequence or a worse result. Now, mistake is that this would be the mistake argument again would go to defeating the mens rea. A mistake of law is no defense. So ignorance of the law, as it's been said, is absolutely no defense. So mistake of the law, someone's ignorance of the law cannot provide them a defense. Mistake of fact, on the other hand, if such mistake is a reasonable mistake, may provide them a defense. Now, the mistake of fact would again have to be a reasonable mistake. A reasonable person in the defendant's position would have absolutely made that same mistake, and that because of the reasonableness of that mistake, the party's conduct should or that the party's criminal activity should carry with it the defense of mistake. Then entrapment. Entrapment is the defense by the criminal defendant that says that the criminal defendant was induced by the police to commit a course of conduct that they were not predisposed to commit. In other words, that they were induced by the police to engage in criminality that they were not predisposed to commit otherwise. And that pretty much wraps up going back to our top of our list here, that pretty much wraps up criminal law. Again, murder, structure, theft, crimes against the person, solicitation, conspiracy, attempt, and defenses. Thank you so much for joining me. Again, make sure to vote. And I best of luck on the bar exam, and My prayer goes out to you. Okay, I'll talk with you in the next podcast.